Some people have called these times unprecedented, said they are uncertain, but I choose to use the word unique. Because in these unique times, we will have unique issues, and we'll also have unique opportunities. For me, I think this is a time for everyone to learn, unlearn, and relearn. We have about 400 people who registered to participate for this webinar, and for good reason also. We have one of the most courageous litigators in this country who is not afraid to tell the bar what to do, and who is not afraid to advise the bench what they should be doing. We have the Chief Law Officer of Lagos State, the dynamo of the Nigerian industry. We have the Government Special Advisor on Sustainable Development Goals and Investment. And of course, let's go to human capacity. We've all been working from home for the last few weeks, and we may not know how we are going to continue to work. They say there's a new normal. I say there's a now normal. Now this is all said, I'm going to hand over to the Vice Chairman of my committee, my good friend, who may soon be partner, depending on if there's consolidation in the legal marketplace after all this has ended. Ozofu, please, I'm going to hand over to you from this point. Ozofu Latunde Ogemudia.
Good afternoon, our distinguished panelists and our participants. We want to thank everyone for joining the webinar and for joining in a timely manner. We have committed to keep to time, and that's why we started right on time. I hope that everyone has had a chance to read the protocol for this event, but just in case you haven't, I would like to go over that. So for the webinar participants, your mic will be muted. The participants will be muted, but will be able to ask questions via the Q&A tab on the Zoom app. You can write your comments or your questions to the speakers at any time in the course of this webinar, but only panelists and moderators will be able to use their mics. In the case of any participants whose questions cannot be answered because we run out of time, your questions will be answered by the speakers, and we will have that emailed to all the participants so everyone can benefit. We will not be able to address any questions that relate to personal matters or are not related to the subject matter of what the participants are speaking about. This webinar is being recorded, so you'll be able to watch it later. We will provide a link to the recorded webinar on various platforms, and we would encourage everyone to feel free to watch it and to share it with their colleagues and their network. Participants should show up on time. Well, most of our participants are already here, but we're expecting a lot more. And once again, I'd like to thank you all for signing into the webinar. Without further ado, I think we're ready to get started.
And the question is yours, Ozofu. Please go ahead.
The first question for today goes to our panelist, Mr. Babajimi Ayorinde. It's on force majeure and frustration in light of COVID-19. And the question is, Babajimi, you recently authored an article in Business Day on force majeure, which touched on several factors that contracting parties should look at in order to determine whether they should raise the flag at this point. What options are parties left with in the event that their contracts do not have force majeure provisions?
Okay, thank you, Ozofu. If a contract does not have force majeure provisions, it's still possible for parties to that contract to be able to rely on the doctrine of frustration. Frustration will occur where, because of an event that is unexpected by parties, which is beyond their control, becomes impossible for them to perform their obligations under the contract. It will also occur if performance will be will result in a significantly different outcome from what the parties had envisaged when the contract was entered into. Um, though we don't have any cases yet in the Nigerian courts or any decisions yet relating to this particular pandemic that we're dealing with, I would imagine that the COVID-19 pandemic would qualify as an event that parties could not have reasonably expected, and an event that is beyond their control. Now, before we start getting carried away, I think it's important to say that the doctrine of frustration isn't some silver bullet that will magically enable us walk away from our contractual obligations. It's actually not an easy defense to raise because our courts generally lean towards holding parties to their bargain. There are a lot of hoops that you have to jump before you can rely on the doctrine of frustration. For starters, you need to prove that there's a causal link between the event you're relying on and your non-performance of the contract. So, for example, if you're planning to rely on the COVID-19 pandemic as the basis for frustration, you need to show how COVID-19 affected your ability to perform. If you had already breached your contract or you hadn't performed an obligation under your contract before the outbreak of the pandemic, you won't be able to rely on the doctrine of frustration. Once again, the doctrine of frustration cannot be used as a way to get out of a bad bargain. The courts would generally not allow you to successfully invoke frustration if the event you're complaining about has merely made your contract more expensive to perform or has made it harder to perform. Now, one needs to be careful and beware of unintended consequences. A lot of people I've spoken with in the last couple of weeks since the lockdown started have not really wanted to walk away from their contractual obligations. What they simply want is some kind of reprieve. They want a few weeks, a few months, maybe a year to give them time to get back on their feet. If you fall into that category, then frustration isn't for you, because if you successfully plead the doctrine of frustration, what happens is that the contract comes to an end. That's one major difference between frustration and force majeure. Force majeure most times would merely suspend the performance of the obligations whilst the force majeure event subsists. But with frustration, it's final, it terminates the agreement. I think the last point I'd like to make, or the last option I'd like to talk about, is that if your contract falls within the band that we refer to as consumer contracts, then you've got help from statute. Section 120 of the Federal Competition and Consumer Protection Act essentially allows parties to ask for a refund of monies that they have paid in advance, subject to a reasonable charge being deducted. So you can actually ask for your money back in the case of consumer contracts. I think I'll stop there so I don't use more time than I've been allotted. I'll be happy to answer questions in the Q&A segment. Thank you.
Thank you very much, Babajim. We've been trying to keep the time, and I think if we've overrun at all, maybe just by 2 minutes. The next question I'm going to pose is to one of Ozofu's partners, Mrs. Folake Iglas Adeboale. And we shared a message over WhatsApp this morning on a distinct transaction, which you teased me on. But let me just go down straight to it. You're conscious of the fact that this pandemic could materially affect fair market value and earning capacity of businesses. What are the issues? What other issues do you envisage will confront parties to M&A arrangements when the dust settles?
Papa, I don't think she can hear us.
Can now, but it's sort of coming and going. My apologies for that. I don't know why that is happening. But good afternoon, everyone. Thank you for having me on this great panel. And Baba, also for the phrase that I was battling you and Bukola about, which is when the dust settles. I think that's much needed optimism in a week when all the media images we're seeing suggest a veritable sandstorm rather than any chance of dust settling anytime soon in all the post-lockdown activity reports we've been reading. So I agree with the first part of the question that the pandemic has and will impact on valuations and earning capacities of businesses, and potentially on concluded, current, and proposed deals. Having said that, from an financials indicate that it has declining revenues, valuation is falling, or it's actually showing a significant improvement in those areas in the wake of COVID-19. Either scenario potentially creates avenues, in my opinion, for opportunistic market activity for M&A deal makers. There'll be sellers who are interested in COVID resilient assets. As I love that phrase when I heard it, which is obviously things like essential services, healthcare, tech, TMT, some e-learning, e-commerce by way of example. And buyers may be interested also in exploring opportunities presented by COVID distressed or negatively impacted assets, such as transportation, travel, hospitality, logistics, and as one of my colleagues said this morning, gaming even in this period. So I think there's opportunities, whether or not a company is doing well or not, but there are some factors that are going to impact on the issues that deal makers may be confronted with, whether and to what extent and how they're going to be able to allocate risks between themselves, which is essentially obviously what they'll be doing in transaction agreements. How do they allocate, or for concluded agreements, how do they reallocate COVID-19 associated risks between themselves? And this will depend on a number of factors, such as the economy. I won't dare go down that route. You've warned me that my commentary must be the length of a shortish jazz song, so I'm going to keep with that. So we won't talk about the economy, but it's obviously a factor, and I had to mention it because of its indelible importance. Then we have the business and the sector, the relevant business and the sector and the extent of its COVID-19 resilience, by which I mean whether there might be medium to long-term prospects for recovery or for growth, which might continue to attract investors to that sector. And then you've got the parties' commercial objectives, which will matter, the quality of the M&A agreements, and the degree to which those agreements have available built-in flexibility that will, if the parties are happy to do so, enable them to perhaps revisit some of the provisions that might have become unworkable in view of COVID-19. The status of the transactions will also matter in the sense of whether the transaction had actually been signed, completed, everything by, let's say, the 25th of February. Remember, the WHO announced, categorized the pandemic as a pandemic rather than a sort of very highly contagious endemic infection that was contained in one area. So that happened on March 11th. So what will be important, for instance, is what dates did you sign your agreement, if you have a signed agreement? So you've got agreements that are signed, deal done, money received, and the key issue there is probably going to be for the parties to renegotiate if their agreement doesn't have enough built-in flexibility. Or there might be provisions in the agreement that are quite stringent. You have a non-COVID resilient business, and parties will need to revisit financial, legal, and operational implications of the impact of COVID. They might not be able to meet their commitments to their under their material contracts. They may not be able to service loans that they've taken, and I know Sheyi is going to talk about that, so I won't go into detail on that. They're not making any revenue because they're shut down, and they're having to undertake unplanned additional expenditure at a moment when their capex should be capped. And for all of those reasons, they're failing to meet commitments that they had made under their share purchase agreement, their SPA. Those issues will need to be considered. What allowance does the agreement make for amending that SPA? Does the buyer already have rights that would have come into effect given the financial impact on the business? For instance, does the agreement
Ms. Adewale, we can't hear you. I don't know if you can hear me. We lost you for a second there. One of the issues that, the whole world is facing right now is technical issues actually using remote video conferencing and whatnot. Maybe Sheyi, should I bring you in now because you seem live at this point? I think she's just facing some data issues. And she's gone a fair bit with her response to the question. Sheyi, would you say these are the same issues you see affect financial arrangements? And if you could possibly shed some light specifically on how these are affecting acquisition financing and what steps—
Hi, Baba, can you hear me?
Yes. Okay. Do you just want to quickly close there? I was just asking Sheyi her question, but if you could quickly close and then I'll bring
Yes,
Sheyi.
yes. I'm going to close it out. Yeah. For new transactions, obviously, you have to rethink how you do due diligence. You need the target, the seller, to be completely organized with its records. You need to have those records as soft copies in case, because of COVID restrictions, due diligence has to be carried out online. You have to make sure that you're able to get corporate, regulatory, and shareholder approvals that you need to close your transaction. Unfortunately, new transactions are the most vulnerable to parties deciding to cancel or defer the completion of the transaction. But by far, I think the trickiest stage of the transaction is the middle bit where you have signed the transaction and then COVID happened before you close. Between signing and closing. But there is hope. As you said, the dust might start to settle. We're seeing transactional activity in many of those COVID resilient sectors. I think that we'll see diversification and hopefully eventually this will be something that generates activity in the M&A market for everyone. Thank you.
And that's what we're looking forward to. So Sheyi, I'm coming to you now. But before that, I want our panelists to know that on the Q&A tab, questions are actually being asked right now. And we've got a couple of questions addressed to Babaji Majeure. One of them comes from none other than Leia Debi. I don't know, Babaji, if you want to answer that whilst I proceed with asking Sheyi her question. So Sheyi, I've gone maybe midstream with the question, but I'll start again. Are these the same issues you see affecting financing arrangements? And if you could shed some light specifically on how these are affecting acquisition financing, and if you could possibly just shed some light on what steps parties can take to resolve them.
Okay, thanks a lot, Baba. And I think Falake has done a good job in talking about some of these M&A issues that one will face at this time. I think that the reality is that any buyer of shares in a target that is looking to be funded by a financier will ultimately experience the issues basically that a target itself is also facing. And the reason why a financier will face those issues, particularly with respect to acquisition financing, is that at the end of the day, the targets, the financier is looking to get repaid from even the cash flows of the target. So if you are looking to get repaid from the cash flows of the target for your acquisition financing, then really and truly, whatever issues that the target is facing from a financier's perspective, you're also likely to deal that too. And I think that I'll take this from a lender's perspective and a borrower's perspective, and then I'll also throw in an illustration to also help. So in your typical acquisition financing, you have a company that is trying to borrow money in order to be able to fund its acquisition of shares in a target. And so let's take two scenarios. In the first scenario, you have a lender that has funded, deal has closed, transaction documentation has been signed, lender has funded, and lender is now worried because the reality of it is that the lender can look basically at the target in question and can see that, look, this target is not doing well because of COVID, problems in supply chains, problems with consumer demand. And the problem is that from the borrower's perspective, the lender itself is then worried because the lender is saying, look, the repayment profile for this transaction or the amortization profile for this transaction was based on forecasted dividend. And that forecasted dividend itself was based on the historical performance of the company. And now COVID has arrived and all kinds of things are going on with the target. So obviously that in itself presents its own issue. Let's take another scenario where the buyer, in this particular instance, the lender and the buyer, they've signed an agreement, but actually the underlying M&A transaction hasn't closed. But let's also see that in this particular scenario, as a closing condition for the financing transaction, right? It's a closing condition that no mark must have happened in relation to the target. And what's a mark? So a mark is a material adverse change. And now COVID has happened. And so you're then asking yourself, okay, and we have actually received questions from lenders who are saying that, do I still need to fund? Can I legitimately refuse to fund? Because when I look at the transaction ahead of me, I can see that, in fact, maybe a mark has occurred in relation to the target. But the reality and the response to that question, which we tell the lenders basically, is that for you to be able to make a mark determination, you obviously have to look at the specific clause in question. You have to also look at the time that mark, supposed mark, actually happened. And you also have to be mindful of the fact that if a court is going to hold that a mark has actually happened, it's going to be on the specific facts in relation to that particular target. So a mark is not a wand that just gives you access immediately to say that, well, to the extent that the global there's a change in the global market or there's a change in global financial conditions, then immediately I have access to a mark. So that in itself is going to prove very, 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 very challenging. And so then let's even look at even the buyer itself. The buyer itself who has even made its own projections on the basis of dividends is in trouble because obviously the target is not doing well. And there's a problem with whether or not it's going to be able to make its own repayments based on dividends that have been forecasted. So these are the different scenarios. Lender who has funded, lender who hasn't funded but is trying to run out or get out of the deal, buyer who is asking itself, oh my God, what have I gotten into? I have made my own projections based on dividends, and now this company may not even make any profits, talk less of a dividend. And these are the issues that you're then dealing. So what to do? What a borrower or a buyer must not do is just sit down and fold his arms and say, well, you know what, the lender doesn't live in Mars. The lender also knows that there's COVID and there are issues. No, the borrower mustn't do that. Instead, what you must do is that you must engage. The lender too, on the other hand, must not also say, well, let me fold my arms and also wait for the borrower to default. No, that's not what will happen. Both parties need to understand that they need to work together and make a commitment towards restructuring their debt facilities. And so a lot of things are going to happen. One thing, for instance, that may happen is that you may talk about the usual extension of tenors, moratoriums, deferred principal, deferred interest. But I think that COVID presents a peculiar situation in this time. And I think that it's good. Lenders are going to have to think out of the box and not just say, well, all we just want to do is do an extension of moratorium. I think that lenders are going to have to actually put on their advisory hats and actually say, what can we do? And that advisory hat, unfortunately, may not earn that lender some advisory fees, at this point. But they may actually have to think about it and ask themselves, how can we actually, help even the target, to even improve its own economies of scale. And those economies of scale may go into something as simple as, for instance, seeing whether or not the target may need to shrink. And when I say shrink, for instance, you have a target that has several subsidiaries that it doesn't need. Target at that point may be, you may then be thinking about saying, okay, how about wanting to then do some corporate restructuring so that you can then shrink and have divisions instead of subsidiaries, so that you can put more efficiencies for purposes of, offshoring dividend. So all kinds of things are going to have to come to place. But the reality of it is that if you take a you versus me approach in this dealing, there'll be a lot of problems and you just have defaults. At the end of the day, the reality of it is this: when lenders lend, they are not lending only on the basis of security. They are lending because there is belief in the ability of the cash flow of the assets, to be able to repay the debt. So at the end of the day, lenders may also need you. In fact, it may even come to a point where you say, look, you know what, in addition to providing advisory advice, to providing advice on economies of scale, we may actually now also need to, inject additional capital so that there is that rebound. And with that rebound, you may then be put in the target may then be put in a situation where it can actually declare dividends again. But I think the focus of the message must be that for acquisition financing to succeed in this period, right, there has to be collaboration. There has to be partnership between lenders and borrowers who realize that, look, we're dealing in uncharted territory here. And there must be collaborative measures and, partnership to ensure that, good restructurings are put in place. And at the end of the day, I'm sure that we'll be able to thrive.
Thank you very much, Shay.
Yeah, extremely well said, Shay. I think you covered all the bases. Parties need to engage. It's not a magic wand. You have to go to specificity, and that's the way forward. Don't bury your heads in the sand. Mrs. Adeboale, Shay, thanks a million. Now we're going to the segment of who I describe as the legends. You see that they're actually dressed differently. You've got one legend in a suit, another is in his kaftan, and the third legend is just easy in his shirt, sitting in his study. I had my first interview with one. I worked for the other, and currently work with the third. Ozofu, I'm now going to hand over our legends to you to ask the first couple of questions.
Thank you. So we move on to a topic that I think has occupied the thoughts of many corporate lawyers in the course of this lockdown period. Certainly has occupied my thoughts and led to engagement with the CAC and other regulators on this issue. And that's the topic of holding meetings, board meetings, general meetings in an era of social distancing, what the law permits, what we can be flexible about, or whether our hands are completely tied. So without further ado, I would like to direct the first question to Shay Bickerstead. And that question is, we all know that nobody is traveling these days, either locally or internationally, and for good reason. As such, companies have had to improvise by holding their board and general meetings virtually. This may be a good temporary solution, but is this going to be the new normal going forward? We would appreciate your views, sir.
I hope everybody can hear me. I'm going to start with the facts, and then I'm going to use that facts, to get to a conclusion. So what are the facts? I think the facts are this, that we have a virus that is highly contagious. We also have a virus that is not going to go away, very soon. In fact, all the health experts tell us, is that we should expect resurgences, as we go about, our lives, from now on. Okay. Based upon that, it's very obvious that nobody is going to feel very comfortable having meetings when we haven't discovered the cure. And the cure is likely to be a vaccine. You're going to be very uncomfortable sitting with people, especially people that are asymptomatic, at meetings. Now, you say to yourself, what is the status of vaccine now? The status of vaccine is that we are probably about 12 to 18 months away from getting a vaccine. It's probably going to take us another 3 to 5 years to have worldwide availability of this vaccine. So if that's the case, it's extremely obvious to me, that we are at a new normal now. When you then add that to the fact, that most people who are board members or attend AGMs, especially in Nigeria, are members of a demographic group which is over 50, which are supposed to be very highly vulnerable, you can see the implication, of having meetings, that are up close and personal. So like I said, I feel that, if you take all these factors together, we're at a new normal. And the key now, to me going forward, is to build the infrastructure and processes to make the new normal effective and efficient. Thank you.
Thank you very much, sir. The next question for Mr. Aswe Kodalo is that the CAC recently issued guidelines directing that AGMs can be held remotely and shareholders should appoint proxies so that they can, the companies can keep the numbers of people present limited to 20. I've heard some queries about this directive. Some have said this is nothing new. Shareholders have always been able to appoint proxies. So really for a private company, what's really the difference? In your opinion, how do you think this affects the rights of shareholders in relation to having to pick from a limited number of proxies that will be enabled to attend physically and generally other rights? So do you see this as an inhibition of shareholder rights?
Thank you very much, Ozofu. And I'm always glad to be within, in and around the SBL. SBL is always very close to my heart. So thank you guys for inviting me. Let me first start from where Sheyi stopped. The world has changed totally, and it's going to stay changed, number one. Number two, COVID is going to be with us for a long time. Sheyi is optimistic. I've talked to a few microbiologists and doctors and things, by the time they go through all the protocols, we're going to probably have COVID for the next 2 years. So we all have to learn to live with COVID. So I'll come to your question. And it's been interesting because since the CAC issued its guidelines, I've had different views. And even in my office, I've had arguments from different people taking different positions. One of the mistakes I suspect people are making is that they're confusing the guidelines with regulations and the ability to make regulations, which is an ability that resides in the minister on the approval of the president, the Section 16 provision of CAMA. And this is different. What has happened here is that our regulator, that is the regulator to administer the act and to manage businesses and the formation of businesses, has issued a guideline. And technically what a guideline is that it's a recommendation. It's a piece of advice. And if we look at it from that perspective, we won't be as bothered as we all are. People call it a directive. And you in your question asking said directing. It's not directing. Really, what it is that we're advising. And we're advising so that life can continue. That's what has happened. So that companies can continue having general meetings or annual general meetings, so that we can continue doing the things we do, and so that the economy can keep turning around. So it's an advice. So I want us to see it from that perspective. There have been provisions in that guidelines that seem to suggest mandatory directives. The use of the word shall in a couple of places. And what we as lawyers need to do is read it in conformity with what the document really is. The document is a piece of advice, it's a recommendation, so there's no place for shall. So we will read it as not being mandatory. That's the only thing that makes sense, and that's the only thing that works. Straight to the question, clearly, without any doubt in my mind, I do not think in any way whatsoever, and that's my opinion, that the guideline affects the shareholders' right to attend or vote at the meeting. Section 81 and 227 of CAMA clearly reserve rights to shareholders to be able to attend, speak, and vote at meetings. But the same CAMA, in different parts of it, especially in Section 230, makes a provision that if you don't want to attend a meeting, if you can't attend a meeting, or if for any reason you can't be at a meeting, you can ask somebody to attend as if it was you. And the same CAMA prescribes that there are two ways actually in which you can attend a meeting. You can attend directly physically, or you can attend through your proxy. So where for any reasons, particularly the facts that were laid out by Sheyi, the pandemic, circumstances of the time, the impracticability of attending a meeting, you can't physically, then the law also makes provision for you to attend through a third party. So the only thing the CAC has done is that because of the circumstances we find ourselves, please attend these meetings through a third party. The federal government and the state governments have prescribed mass gathering limits. So if we're going to comply with those mass gathering limits, then we have to become creative and inventive within the provisions of the law. So the law prefers an alternative way of attending the meeting that doesn't entail you physically being there. People in Sheyi's age brackets cannot afford to risk going to these meetings because they don't want to catch anything, whether the things are there or not. So basically, we will take advice from a regulator. And where people think it's mandatory, it really is not. It's just that we're wise in this environment that if your regulator advises you, you should listen to that advice. There are certain things they've asked for that are in conflict with CAMA, and it doesn't invalidate your meeting if you don't do those things. But the important thing is to take the advice. And it's clear to me that if you follow the prescriptions of CAMA, Section 230 is clear how you will attend a meeting by proxy. Sections 224 and other sections suggest how notices will be issued. For me, the key would be that each company should properly issue its notices so that everybody knows the business they're coming to meet. And all of those companies also should now properly design proxy forms so that the proxies their appointer chooses will be able to take direct instructions from their appointer as to how to vote, and if they're coming to make comments at the meeting, what comments they should make. CAC has suggested that only ordinary business, statutory business, should be conducted at these AGMs. I'm not quite clear that CAC has the power to do that, but since it's a recommendation, it's not a problem. So what that does is that the proxy form should be clear as to how you respond to all of those issues. What are the issues? Financial statement presentation, director, auditor report presentation, declaration of dividends, either you're accepting it, yes or no. So you can ask your proxy to vote. That's not difficult. Appointment of directors. You see the list of directors. You can say, vote for this, don't vote for that. So it's quite straightforward. And the law preserves the right for you to attend the meeting in this way. So I don't see any problem. I think it's a good thing. And CAC is trying to be proactive. We've all accused CAC in the past of being in the Stone Ages and being dinosaurs. So it's a good thing they're being proactive. So what we as practitioners should do is commend their proactivity and read it in line with what the law says we can do. We cannot go outside what the law says we can do. So I'm quite happy with the proactive nature of what CAC has done, particularly for those companies that must have their AGM because they're time bound by the provisions of Section 213, or for reasons of commercial exigencies. There are some companies that want to declare dividends very quickly so that you and I can collect our dividends and go home. So I think CAC has tried to be proactive. I don't think there's anything outside the law, and I don't see in any way in which shareholders are precluded from exercising their rights. Thank you very much.
There you have it.
that nothing more than guidelines. There's no directive, even where the regulator had chosen to use the word shall. The regulator truly doesn't have the authority to do that. If the letter of the law says what the regulator can do, its limits do not go beyond those letters. We've heard from two of our legends. And thank you so much, Asu Gudalo and Sheyi Biggersteth, for your words of wisdom. So I come to legend number 3. Once upon a time, I was sitting on the other side of the desk and you were asking me the questions. So I'm only too happy today that I am the one asking you the question. And it's very simple, sir. It's obvious that the pandemic has had and will continue to have a disruptive effect on the way companies manage their affairs. You've been in the business space as a shareholder, as a director in several companies for well over 25, 30 years. Now, I think there's need for reform. We're facing present issues. But in your perspective, what reforms would you say we need to ensure that our company law is able to deal with the challenges posed by a post-COVID-19 business environment? Ideally, Ozofu, you should have asked this question because you had a hand in some amendments to existing CAMA. But over to you, sir.
Thank you, Baba Shala, and again, thank you to SBL for providing the platform to talk about these issues. Look, as Sheyi Biggersteth said, look, we have significant issues around us with respect to COVID, the pandemic, and how we're all going to deal with it. But I think to put some markers on the ground, in an era of whether you call it social or physical distancing, it becomes critical that we're all not going to be able to sit in a room, whether it is for a board meeting if there are more than 20 or 25 of us, or an AGM where there are more than 1,000 of us. So it's important that we put rules in place that will resolve issues for us. I think the other thing is that there's going to be a significant disruption around traveling. So whether it is traveling by road to attend meetings or traveling by air, chances are that we'll all like to join meetings virtually on the phone. I think the other thing that Sheyi is also alluded to is that there are going to be waves of this pandemic. So the fact that they've let us out of jail right now doesn't mean that we're out of jail for the next 1 year. It just means that we've come up for air and things may change very, very quickly and rapidly. I think in the middle of all of that, it's clear that the rules that we have today, and as we talked about, how we're interpreting CAMA, the reality is that the rules we have today are not fit for purpose. What's the purpose? The new normal that all of us are going to have to live by. So I think it's particularly clear that we need to change CAMA. I know that there is in circulation a bill. That bill needs to be revisited in the light of everything that we're talking about now. I think one of the things that makes it even clearer that we need to amend the law is the announcement that the CAC itself put out that takes effect from today. That says that they will only allow 50 people into their building at a time, but they will only allow 20 inside the building. So the other 30 people get to sit out under the canopy in the hot sun. And that even when you go in, you can't do physical or manual searches. So what's the point of going there? So we do need to understand that inherent in what we are living with today is the reason why we need change. And that change better come sooner than later. I think it's important, therefore, that we digitize the whole of the CAC. There's actually no need to go there. If I can incorporate a company without going there, why do I need to go there to search the records? And so those are some of the things that are particularly important for all of us. I think the other thing is around the meetings that Aswe has talked about. Today, it's possible for us to attend board meetings without all sitting around the table. That's because we have provisions in our articles that allow us to do conference calling. The reality is that we shouldn't even have to wait for an article to provide it. We should just pretty much say to everybody that any meetings of a company, be they committee meetings, board meetings, general meetings, of whatever name that you call them, we should all be allowed to attend these meetings virtually. And we need to put that in the laws. I think the other thing is around notifications. I mean, we still have provisions in our law that say that the only way that I can prove that I sent an annual report to a shareholder is to bring the DHL slip so that shows that I sent it out. Well, that makes no sense in today's world. Who's distributing any mail today? And yet, we do need to have our meetings. So I think, again, that it's important that we create rules around people receiving their notifications by email. I mean, shareholders don't complain that they no longer get dividend warrants. Before they stand up from an AGM, the money is hit their account. So why don't they just want to receive an annual report, either that it's published in the newspapers or that we send it to an email address that they provided? So I think that those kind of things are particularly important for what we do. Again, in conclusion, reality, everything that we do with the CAC, and maybe not just the CAC, with any regulatory agency that we submit papers to, that we are allowed to do online filings. No need to go there and try and engage anybody physically any longer. And I think, look, let's take a cue from what and I know Yemi Kandi Johnson will talk about this, but let's take a cue from what the litigators are battling with today. The reality of life is that who wants to go and go to court if you don't have to? If I can sit and file my papers and actually present by Zoom, then who wants to actually show up in court? The arbitrators are already doing it and are doing it extremely well. And I think that this is what we need to recommend all around. The US Supreme Court, for the first time in history, did a virtual sitting on Monday. Now, that's the way to go, not just for the courts, but also for all of us that have to engage regulators, whether we are above 60 or not. There's some of us that won't even go near, and whether you have underlying conditions or not. I think it's important that the new normal that we all face is a new normal around having to do things virtually and online. Thank you.
Powerful. True words of wisdom from three legends. I trust you'll all agree with me that we've taken the benefit of their wise counsel and their experience, having been in the legal marketplace and the business environment for a considerable period of time. We're going to the next segment of this discussions, which is in relation to the administration of justice and retooling our court system. So I'm going to hand over now to my partner, who is very excited about this area. And I'm sure he's pretty excited about asking the next discussant the pertinent question. And in fact, he came up with a comment this morning, and I said, "Don't change the question, please. You may send the comment to the gentleman, but please let's keep to script." So Babajimi, I'm handing over to you.
Thank you, Babashola. The next question is for Mr. Kandi Johnson. Okay, so now I can see you. Mr. Johnson, I watched your interview on Channels TV where
I seem to have lost you. Okay.
Babajimi, are you having data issues again? Are you going to switch between service providers? Yeah, I think you need to start again, Babajimi.
Okay. I was saying that I watched your interview on Channels TV where you proffered solutions for keeping our courts running during the lockdown. Since then, Borno State Judiciary has earned the bragging rights for holding the first virtual court proceedings in Nigeria. Back home in Lagos, the Chief Judge of Lagos State has issued practice directions enabling remote hearings and electronic filing. At the federal level, the NJC has set up a committee to come up with strategies that will ensure that courts continue to function during the pandemic. Now, given that the adoption of remote hearings is only one aspect of the reforms required in our system of administration of justice, what other reforms do you think have become more urgent and compelling as a result of this pandemic?
Thank you very much, Mr. Yorinde. You know, justice reform has been urgent in Nigeria for decades, but now it's been taken out of our hands. We're through the looking glass, and the virus may be the opportunity for unexpected progress.
And I like to put this thing in context. You know, the value of an expensive system of justice has to be proved by its users, who are the real owners. Trading companies, banks, insurance companies, SMEs, ordinary individuals, and even criminal defendants who use it daily at their cost and risk. All key indices will tell those people that the Nigerian judiciary does not give value for the considerable financial outlay, every possible index by which you can test it. Now, the public's legitimate expectation is efficiency and effectiveness. And for this reason, justice reform is too important just for judges and lawyers alone. The second topical point, which has arisen now, is public access to justice in circumstances where physical locations and human proximity have become dangerous. The emergency highlights the fact that justice and courts are not a place, but a service. I think this is what Professor William Susskind said. But here we're obsessed with ceremony and with rank and titles and impenetrable forms and language. We're obsessed with physical spaces which are hostile to the public, inaccessible. And now we're forced by this virus to acknowledge that those anachronistic things are no longer important. Now for Lagos State, it's very important because we're in Lagos State, and I'm glad that my friend, the Attorney General of Lagos State, is on the panel because he's a leader in this respect. Lagos State is more than 60% of the national economy. So what happens in Lagos is critical for the whole of Nigeria. And the judiciary in Lagos has indeed shown us some direction as to how progress can be made. In recent years, as many people know, Lagos judiciary has extensively remodeled its approach to justice delivery so that it is more approachable, it is fairer, it is more rational, more efficient, and more effective to resolve disputes on their merits, which is the task of courts, to resolve disputes on their merits. It has even dramatically, as we saw in the last week, proved the use of modern technology in a remote criminal court session, which was, of course, high-brushed the next day by the Chief Justice of Nigeria. But to meet the challenge that we face, which is one of a tremendous backlog, we have a backlog of maybe 200,000 cases nationwide. All our courts must now diligently embrace a modernizing vision. They must deliver a public service that is driven by results. This is the approach that we have seen exemplified in Borno State under Chief Judge Zana, and also in the Court of Appeal by Acting President Dongban Mensam, as I said, before the Chief Justice put the skids on that particular development. But members of the public, the owners of the legal system, need to hold the judiciary closely accountable for money spent and for service delivered. It is only the quality of their service that will command reverence. We're entitled to judges that we can esteem in this way. It's not about a high chair, it's not about a fancy robe. Nigeria is entitled to a transparent and auditable system of judicial appointments and promotion, a process which will elevate lawyers with verifiable skill, experience, and ability, and who exhibit the highest professional standards. As you may know, there is already some sort of scandal erupting about the recent appointment of 70 judges by the National Judicial Council, by a process which, by public account, appears to be deeply flawed and at the very least suspect. That is a big problem. Now, that's judges. The second aspect is lawyers. We need to rewrite the education training of a generation of Nigerian lawyers who have become accustomed to professionally irresponsible and unethical behavior and who have been rewarded for it. Unless the lawyer is digital, adept at approaching and deploying technological resources and solutions, he is already legally extinct. So add that incapacity to a capacity for corruption, then you have a very dangerous situation for the public. As to the legal process itself, we need to demystify, to simplify, and to abridge court processes to make it easier for judges to identify and decide the substance or merits in a way that is most economically using the limited resources available. We need to raise the threshold for cases that are so that futile or merely speculative cases do not clog the court's dockets. Some of the changes require legislation and even constitutional amendment. For example, control of judicial funding, discipline, and regulation by a secretive National Judicial Council is deeply problematic on a political and legal perspective. Other solutions just require simply imagination, attitude, and effort, making administrative processes open, simple and auditable, archiving of files and records in an orderly retrieval system, early neutral evaluation of filings, and triaging them into appropriate lanes, ADR or not. 60 to 70% of court time is taken up with interlocutory proceedings, which can mostly be resolved on paper alone. In the appellate courts, the courts are convened to hear trifling arguments. For that to happen in the appellate courts is a national embarrassment. Ours is probably the only Supreme Court in the whole world, in which people hear in open court stay of proceedings, amendments, leave to appeal, extension of time. Now, even injunctions can be decided on paper alone. There will be very, very few appeals that cannot be summarized orally by a skilled and well-prepared advocate in less than 30 minutes. Remote hearings, which we have now started, are going to teach us about how to use our time. Are going to teach us that you can strictly regulate counsel in their written and oral submissions, and that you can dramatically improve both the quality and the advocacy and also the outcome for our courts. Now, Baba Lokorolaro started off by saying we should start with signs of hope. I like to get to the point, and so often I will be guilty of sounding like a prophet of doom. So let me finish with a point of optimism. I think that Nigeria has in abundance the intellectual resource. Just on this panel here, on this whole session, is the intellectual bank of Nigeria right here. And so people will wonder why with all these intellects, we're still so backward. It's a matter of will. It's a matter of disrupting the will which points us in the wrong direction. So we have these resources and we can overcome the challenges that we face. What we need is brave and progressive leaders, especially in the law, and then we need an inflexible will. Inflexible will from lawyers, from the owners, and the users of the legal system. It's not sufficient to say that the judges don't like it, the senior lawyers don't like it. The legal profession and law practice and the system of justice does not belong to the lawyers. It belongs to the people, and it's for them to take it back in this situation. Thank you very much.
Wow.
Thank you, Mr. Kenneth Johnson. It's always a pleasure to hear you air your candid views, pun intended, on judicial reform in Nigeria. I just hope that one day somebody listens and things actually start to change. So without further ado, I move on to the Honorable Attorney General of Lagos State, Mr. Majeure Onigbanjo. As I had said earlier, the Chief Judge of Lagos State recently released practice directions that have enabled remote hearings. Only on Monday, 2 days ago, I think the Honorable Justice Dada of the High Court of Lagos State delivered a judgment using Zoom. And I believe the Honorable Attorney General was actually part of those proceedings. Whilst I think everyone will agree that this is a step in the right direction, is there any concern that these practice directions can be challenged on the grounds that they violate standards of fair hearing, such as the requirement that an accused person should be present at his trial, and also the requirement for court proceedings to be held in public?
Thank you very much, Baba Jimmy. So, well, yes, there is no doubt that we're going to have that challenge. It's not a matter of if, but when, because we know the attitude of most of our colleagues who, as has been aptly put, are stuck in time. But doing nothing is not an option for us. We must expand the frontiers of our law, of our legal system. It can't just be static and people tell us that, oh, you can't do this, you can't do this. But if you look at the law itself, I believe that there is room for the interpretation to say that we have met all the requirements of a fair trial for the accused. It depends on what interpretation you want to put on public. So people think that it has to be a physical space. But happily, there are some decisions of the Supreme Court which expands the meaning of public to say that you can even have proceedings in chambers, provided the chambers is accessible to the public. There are also, of course, there's also other decisions which say that proceedings in chambers are unconstitutional. But more importantly is that section 36(4)(a) of the Constitution recognizes that in certain instances, public trials can be excluded. And the exception in this case is where public safety is an issue. There is no doubt that everybody knows that the pandemic constitutes serious threats to public safety. So do we continue to bring people together in a situation where we endanger everybody, the judges, the parties, and the lawyers themselves? The answer is undoubtedly no. And then we must then use the law to fulfill the spirit of the Constitution. So the pandemic is there, public safety is endangered. In the case you referred to before Justice Dada on Monday, the defendant was present via Zoom, sitting in the correctional center, viewing the proceedings. So the question is, was he present at his trial? Yes, he was. Was the proceedings of that day accessible to members of the public? Yes, it was. The Lagos State Judiciary published on its website the ID and the password to join the proceedings. And I think they had about 99 people who joined. Everyone who sought access was granted access. So to that extent, we are confident that when the challenge comes, we will be able to surmount it. We're also confident that, so the cases that I referred to, none of them dealt with the issue of public safety and a pandemic such as we have, curtailing the right or the possibility of the public to access the courts. And we believe that once those facts and the interpretation which we put forward to the provisions of the Constitution, we believe that once those are put before the court, undoubtedly they will agree with us that yes, all those requirements of a fair trial were met in this particular instance. Thank you very much.
Thank you.
Discipline of time. Yeah. I just said the discipline of time, that was done in 3 minutes and 50 seconds, giving the next session an additional perhaps 1 minute plus. Time's far spent. I think we have overspilled some time with some panels or with some sessions, but I think it's been a pretty informative discussion so far. And as Mr. Candy Johnson did say, this is the Intelligence Bank of Nigeria. As the member of the board, perhaps we vote to appoint our chair or take that on to be decided later on. I don't know how we're going to pay for the equity, whether it's sweat, cash, or a mixture of the two, who's going to do the valuation, but I'm more than happy to be a part of this bunch. So Lagos State government, represented by two of its public servants here today, eased the lockdown after a directive from the president itself gave further guidelines on how the lockdown in Lagos would be. So let me correct myself. The lockdown was eased by Mr. President himself, and then he gave latitude to the Lagos State government to give further directions, which they have since then done. We've been working from home for the past 4 weeks, for some maybe longer, and it's become the new mantra of every company, of every firm. We've all issued statements as to how we've been working, but it's been as confusing as it has been perplexing for both employers and employees. And the reality of most businesses is that they will have to continue to strike a balance between many competing issues, ranging from the safety of their employees and their stakeholders to prioritizing the profitability of their respective businesses. In the US and the UK, all manner of measures have been taken by the top firms. So now I'm going to ask our human capacity development expert, who's one of the best in the country, Mrs. Bisola Longe, to just give us tips. What tips can you give businesses to help them sustain productivity and achieve the right balance? Mrs. Longe. I think your mic is still muted.
Hello, can you hear me now? Yeah, thanks for having me and a very gracious compliment. I'll be really quick because I know we've overrun time. For me, there's no doubt about the fact that safety is more important than productivity, because, I mean, it's better to be alive than productive. But thank goodness, they're not mutually exclusive. So the truth is, everybody uses the well-worn phrase now, new normal. The truth is that in the new normal, most of us don't need to come physically to the office to work. And I think the sooner most organizations start moving that way, the better. If your people have to come to work physically, I think it's not that difficult to make safe transportation arrangements, socially distanced buses, masks, sanitizer, and get them in and out of work at a good time. But the truth is, if we look at these 4 things, people can work from home very productively. And I'll just very quickly go through the 4 things I think create productivity in working from home. First is communication. The first thing we need to do is issue a work from home policy. Let's not assume anything or take anything for granted. So in the work from home policy, we let people know the hours they should work. We let them know when to submit their reports. We let them know when meetings are held. Let's document everything on the work from home policy and send to everybody. The second thing is, before we start talking about, the hardcore productivity, we need to really think about the mental health and well-being of our people. And it's not just a cliche. I don't think many of us realize, especially the fortunate ones, the more senior lawyers, realize the kind of living conditions even some of our junior colleagues work in. You'll be surprised that some of your colleagues live in 1 room or 2 rooms with their families. So it's important to ensure that they're well, to ensure that we're flexible with their hours, because there may be some situations where they can't work from home in some hours, like people that have very young children or people that have families in a very small space. In fact, some of your people may need to work like at night. I have my 2 children socially distancing, whose habits are very different. So one stays awake at night and one stays awake during the day so that they don't upset each other. So you may find you need that kind of flexibility. Also, we need to make allowance for domestic dysfunction. Some of our people actually come to work to run away from dysfunction at home. So in those cases, for those people, we need to actually put them amongst the people that need to work from the office and arrange, socially distanced transport for them. The third thing is physical issues. Do they have a physical space at home where they can work? And then we've all seen from this webinar, working tools. I have had to get 3 different internet providers so I can switch from one, as we've seen some of us have done in this meeting. So let's provide that, because that influences productivity a lot. Pardon me. And then finally, hardcore productivity issues. Having, given them the tools they need, make sure their laptops work properly. Let us ensure that we have proper timesheets. So let them record their working hours, let them record the work they've done. Let us properly plan and schedule our months and our weeks. So let's ensure that at the beginning of the month, they have their work plans and meetings. And then the beginning of every week, Monday morning, let's have meetings to discuss what's going to be done that week, the challenges from the previous week, and what they're going to do in this week. Do the same thing at the end of the week on a Friday, and let them submit their timesheets, let their managers, the supervisors, look at what they've done, have a status meeting. And you'll find that once we get into the habit of doing that, productivity is quite, seamless working from home. So I think that's my 4 minutes, and I'll hand over back to you. Thank you.
Just perfect. That's the route to productivity we've all just been told there. Understanding of the employers, having the welfare of their employees in mind, keeping timesheets for working from home. That appealed to me. So we can actually judge how much work is being done on this WFH time. Thank you so much, Mrs. Longe, for those words. Ozofu, I'm going to hand over back to you now, so you can carry on with
Thank you. It gives me great pleasure to turn now to our chief host actually for this event, the SBL chair, Mr. Sheni Adio. So I'm going to be speaking to you about the cutting the wage bill. What are the legal options that are open to employers? I'm happy that this is coming after Abisola's presentation, because that gave us the perspective of what the employers should do to ensure that the employees can work in a safe environment and remain productive. But I'd like us to also look at this from the point of view of the employer, starting by focusing on the viral video that I think most of us saw, illustrating companies' reduced business activity during the lockdown, massive loss of income, and the need to cut costs. So the question is around the buzzword follow. In the Nigerian context, can employers unilaterally reduce employee salaries? Is there any support from the government to incentivize workers to keep employees where they can see that the income in this period is not going to be able to sustain that? And then if you have any time at the end of your presentation, maybe you could talk to us about one takeaway you would give to employers in order to cushion the most severe effects of COVID-19.
Thank you, Ozofu. Can you hear me?
So, Asa was
Yes,
telling me
loud and clear.
the way I spoke.
Yes, thank you very much, Ozofu.
Go on.
Before answering the question, I made an observation that practically all the presenters thus far, the male presenters, have facial hair. Then I realized that Baba Jimmy is in good company, that Mr. Gudalu doesn't. So, because I was thinking that perhaps there was some kind of conspiracy that we all have to have facial hair in order to be on the panel. But to answer your question, the short answer, broadly speaking, is that an employer cannot unilaterally compromise the rights of an employee. That's broadly speaking. Typically, what would happen is that an employee would have a letter of employment. So that should be the starting point. If there's one thing I'd like to leave our listeners, the delegates, with, it's that sanctity of contracts. The phrase sanctity of contracts is very, very important. So an employer ought to start by looking at the employee's terms of employment, usually contained in the letter of employment. Oftentimes, it may also be in the employee handbook. Usually, the employee handbook would also contain terms and conditions that affect different categories of employees, so to speak. And then in some circumstances, you do have workers that have their terms and conditions or employment conditions being governed by what is referred to as collective bargaining agreements. So the short answer is that the starting point for an employer would be to look at those documents and then engage the employee or employees, as the case may be. Now, having said that, I think the theme from which we've all been speaking concerning this unfortunate, what I call noisome pestilence, is that it's been very devastating for all of us. Most of us have been impacted in one fashion, but actually all of us in one fashion or another, some very, very dramatically and gravely. So I think employers have to be somewhat empathetic about how they deal with their employees. So to the extent an employer wants to vary the terms and conditions of an employee, for example, there should be an engagement, there should be a discussion. Otherwise, the laws that protect the rights of employees, specifically the Labor Act, for example, and it provides certain protections for employees, and employers will have to comply with those. Now, the options available for employers, typically you have three. One would be to reduce salaries. I personally consider that as perhaps the least negatively impactful option. And I say least negative because at least it's a reduction. There could be a discussion. If the employees are amenable to it, then perhaps the employer may want to have the employees sign onto some form of an agreement acceding to that compromise, if you will. Secondly, you have the option to furlough employees. Typically, when you do that, it's as though the employees have gone on a leave of absence. And I think that also, that's a bit more impactful negatively, because if you're on a leave of absence, typically it's unpaid. So you're not earning a salary, but ostensibly you still have your job, so to speak. But it's an option that certain employees take because the employees rather psychologically still feels that I have a job. The employee can go on and do various things, maybe some of continuing education, take time to spend time with family, and various other things that you can do. Also psychologically, to the extent you're a good performer, you don't feel as though you've lost your job for no reason. So, and hopefully when circumstances change and the employer is able to afford a higher payroll, that employee will be asked to return. From the employer's perspective, it's also somewhat beneficial because, particularly for employees that are very well appreciated, that are very useful to the organization, you want to keep them. You want to keep them close so that when things turn around, you can have them come back instead of having to recruit totally new staff, so to speak. And then finally, you have the option to terminate the employment of your staff. Again, you still have to refer to those three, broadly speaking, documents I referred to, or agreements that I referred to: the letter of agreement, the employee handbook, and of course the collective bargaining agreements. And then, as much as possible, an employer needs to adhere to those terms and conditions. If for some reason you cannot, because again, we all know what has happened, I think most reasonable employees will try to work with the employer to come to an amicable landing, so to speak. Otherwise, the employer would have to comply with applicable rules and regulations. In the case of the Labor Act, for an employee that has only worked for less than 3 months, then all that person is entitled to is 1 day's notice. If it's someone who's worked for about a period of, I think, less than 2 years, then a week's notice, and over 2 years, 2 weeks, and then over 5 years, a month's notice, or payment in lieu of notice, so to speak. So to answer your question, the short answer is that, ordinarily speaking, an employer cannot, pardon the phrase, really compromise the rights of employees. Having said that, that's not a license for employees to now think that they can hold the employers to ransom. I think that there should always be some give and take so that a happy medium can be accomplished. Going back to the example that you gave about the video that went viral, I don't know what video you're talking about, but my understanding is that there's been an intervention by a regulator, and that decision has been, as we say here, stepped down. And it's being looked at. And that's an example of government intervening to assuage the negative impacts of this horrible pandemic on the population. I'm aware, for example, that in the US, Congress passed a statute that essentially provided several billions of dollars to employers on the condition that for those employers that accessed that intervention, the palliative, so to speak, they undertook to retain the employees for a certain period of time. So if you access the fund, then you couldn't terminate your employees. I don't believe that has been done here yet, or something similar, but certainly there's a role that government can play to try and sort of assist and come to the aid of the population, so to speak. I think that answered your question, and I think I'm within time. Thank you very much.
Thank you very much, SBL Chair. That was very helpful, very enlightening for all of us. I'm going to move quickly because we're behind time. So I'm going to move quickly to Mr. Irukera, and we're going to be talking about the FCCPC's response to curbing monopolistic tendencies by companies. Since the onset of the pandemic and the lockdown, there's been a steady increase in the cost of goods and services. Business owners are also groaning over the increased cost of doing business. With an expected devaluation, job losses, and uncertainty about the future, people are expected to spend less, thereby reducing the demand for goods and services, which will further fuel the price hikes that we're already experiencing. Companies are looking for ways to cut costs in order to achieve business sustainability. Against this background, we would like you to discuss with us what the role of the FCCPC is in ensuring consumer protection from unjustifiable price hikes, while at the same time recognizing that businesses need to be able to survive.
Thank you very much, and thanks for the invitation. It's been such an enriching time listening to everyone, especially the legends and the learned Attorney General. And so there are two things here, and it's a conflict that we've repeatedly had to address. And that's the question of the normal market forces with respect to supply and demand, and what is potentially considered excessive or unjust pricing or profiteering, if you may. And there seems to be a thin line in the sand there. But what we've done is we recognize that this was potentially going to be an issue. And so on the 28th of February, almost immediately after the index case in Nigeria was identified, we put out an advisory noting that price gouging, which is excessive, unjust, irrational, or unreasonable pricing, was a violation of statute, not just common law principles, but specific provisions of the Federal Competition and Consumer Protection Act. And so we opened a broad investigation and market intervention on that. And so we're analyzing some of the key pharmacy and supermarket chains at the time. And it seemed like we brought it under some level of control. The focus at the time were certain basic hygiene products and some medication, essentially supplements like vitamin C, then hydroxychloroquine and chloroquine itself, and then for the basic hygiene products, face masks, medical devices like infrared thermometers, and then medical supplies like hand sanitizers. And so that was the focus of inquiry at the time. But as we moved close to the lockdown, I suppose the market again started taking advantage of what seemed to be an additional surge and a potential lack of capacity for surveillance work. And so we took what people might consider precipitous, but we just think it was just unprecedented. So we filed criminal charges against 4 of the chains that we had been investigating. And so we intend to continue with the prosecution anyway. And so that's that. But having said that, we've continued to see a significant gorging, especially now in food items, in addition to the previous items. And there's absolutely no way of staying on top of this, even with our full capacity, much less now that there's limited capacity. So one of the things we've did is we set up a completely different platform to receive reports about this, where people can upload just the name, the address, and location across the country. And so what we're doing is we're analyzing all of that, we're harmonizing that, and so we intend to prosecute quite a number more after the fact. But what we would say is that we've been engaged by the Pharmacists Association and other market associations, and I think that there's some level of sensitivity to the issue, and that is modifying behavior. And so as bad as it seems, one can only wonder what it would have been in the absence of intervention. And in the period, we've identified some key areas where there's serious complaints of violation. Certainly banking transactions, internet service providers, and telecommunications data issues. Those are the areas where we're seeing quite a number of problems and a lack of transparency, both in billing and quality of service. For the internet services, for the most part, there is also an infrastructure challenge. There's a traffic problem for bandwidth because of obviously an unprecedented amount of use. And so we're working through that one day at a time. Looking forward to a broad virtual meeting with senior level executives of all these service providers next week. The biggest thing we're seeing is just what seems to be a arbitrary billing for data use. And so that's on the price gouging side. We opened a large investigation into a key staple material in staple foods because of what seemed to be a unilateral, significant price increase in their business. What we haven't been able to determine if this was just a straight-laced consumer protection price gouging, or whether it was coordinated conduct because there had been some M&A conduct in that industry quite recently. So we're looking a little deeper to see if that's a coordinated conduct or if it's abuse of dominance. And so that's on the competition or the investigation, whether there's a collusion or monopolistic behavior side. With respect to the other competition areas which you've identified and which you started with in discussing M&A, the fairness test remains the same. The rules are the same. Essentially, the provisions of the statute identify the basis where a merger or a business combination would be permissible. That hasn't changed. But what we are doing is we are fast-tracking certain notifications under the merger rules. One is where there's a failing firm involved. And so obviously we're looking to try and do what we can to support the market in that regard. Others are some of the issues that have been identified where the timelines to the transaction, to consummation of the transaction in view of the strict provision of the law that prohibits implementation in the absence of an approval. And because we also recognize that in other jurisdictions, businesses are beginning to open up, we seem to be on the back cusp of the infection rates. And so there is the potential for our businesses not to, and I mean, of course, regulatory oversight, not to load up as quickly as it's going to happen in other jurisdictions. So where business combinations need to proceed very quickly in other jurisdictions, we're making also the exception. And so what we've done is we've created an interim remote notification mechanism. We anticipate in the coming weeks that will become more robust so that we can file all the notification documents and make all the payments online also. But in the interim, for the urgent notifications, we're doing that. We've also issued guidance to the market with respect to restrictive agreements and how we would construe or interpret the law or exceptions from it when it comes to what might be perceived as conspiracies between market operators or competitors. One of the key areas is the supply chain and the procurement process for competitors. For instance, the government is trying to promote small scale businesses, especially in medical devices and supplies, and making hand sanitizers, making face masks, and converting existing business machinery to what can assist with these types of products. And so we're relaxing the rules and we're taking a broad interpretation to joint procurement. So you have two small hand sanitizer businesses who want to purchase alcohol together, and alcohol comes in such large drums and quantities. And so they can cooperate. However, we insist that they maintain the appropriate firewalls with respect to sharing business regarding pricing and market operations. And we understand that coordination sometimes needs to occur with respect to pricing, but we're looking at those ones on a case-by-case basis. And we're also put out the guidance that says that we're issuing block approvals for exemptions under Section 60 with respect to restrictive agreements. And so we're doing whatever we can to support moving businesses along during this pandemic. But the flip side of this also is both for the M&A and certainly for anti-competitive practices, there are certain businesses that are positioned to take significant advantage of the pandemic. One is businesses that are, e-commerce businesses, certainly delivery businesses, online shopping. And so we're obviously scrutinizing their conduct. We're looking at each of those companies when they're looking to take over supply chain service providers like other delivery businesses, and trying to make sure that the appropriate conditions to ensure that there's no vertical integration that ultimately distorts the market is going on. And then we're also making sure that they do not act as a trade restraint to the smaller ones, and there's no time or extraneous conditions to doing business with the bigger ones. So it's quite an interesting time, and we'll continue to look at this as best as we can. For the enforcement on the consumer protection side, we're having some problems with human capacity and being able to put enough boots on the ground. But we're using technology as best as we can. Thank you very much.
Thank you very much, Mr. Rukera. That was very helpful, very enlightening. I think we're going to our last panelist for the day, and I'll hand over to Baba.
Thanks so much, Ozofu. Mr. Rukera, thank you so much for those words and the initiatives that your commission is taking. I'm coming with more or less at the last question, and I must thank all our panelists for staying this long. I know one or two panelists actually said they may have to, get off at some point or the other, and perhaps we only even had just 5 to 10 minutes. And I thank you, particularly the legends. They're still here. There's a quiet legend in the house, and maybe he thinks I can see the list of participants, and I can say to you categorically, we've had in excess of 160 participants sustainable throughout the period of the session from when we started. At some point, we're at 200, we went to about 180, and I think we're about 170 something now. So, I mean, to the participants, I really thank you for just being a continuous part of this webinar. So I'm going to our next public officer, and it's a good thing that we're also engaging here between the private sector and the public sector to see the initiatives that are being taken and, nuggets of wisdom from both sides. So I'm moving now to Sholakwe Hammond, who is the special advisor to the Lagos State government on sustainable development goals and investment. Now, Sholakwe, considering there's a need to balance competing considerations of reviving the economy and protecting public health, can you share Lagos State government strategy with us on the eased lockdown? But before you answer that question, permit me, I know a number of participants have been asking if we could switch to active speaker mode. All I need to say, all you need to do is actually to click the button on your screen to active speaker mode, and then your screen has the speaker that is on at the moment. We don't need to do anything from this end. And apparently, our tech guys have just said to me that we're actually on active speaker mode. So Sholakwe, if you heard my question, over to you.
Thank you, Baba Shola, and thank you, TNP, and everyone who's been responsible for creating this. It's been very informative for me as well. So what happens post-lockdown? And I know that, there are a few concerns, about how to manage this entire process. Should we be locked down? Should we extend it? Should we, call it a day and just open up the gateway? And the truth is, it's very difficult to keep a city like Lagos locked down indefinitely. Apart from the economic concerns that come to the fore, we also have psychological needs of the people. I think Mrs. Zonge touched on that. We also have security concerns. And above all, we have supply chain challenges. So even in the time when we had the essential services working, some of them started needing non-essential services. I mean, I guess it just proves everyone's sort of important. Packaging, suppliers, even stationery, technicians to fix, equipment, things start to fall apart at some point. Also, we import the bulk of our food, whether we're getting it from international sources or we're getting it from within the country, from other states. So it would have been a challenge to sustain this endlessly, even if we don't consider the economic implications of it. The point has been made earlier as well, very pointedly by Mr. Igodalo, saying COVID will be with us for a long time, possibly for years. And so, the lockdown bought us time to put facilities in place, to build capacity and to learn, because no one in the entire world understood or even still understands this pandemic fully or how to handle it. And different countries are trying different measures, and it's just become obvious that everyone's had to learn. But sooner or later, at some point you do have to lift. And so we've, eased partially into it. If you recall, we actually started off with a partial lockdown before easing into a fuller one. So with the lifting, our strategy will remain working together. I think one of the things Lagos State has done particularly well is engaging with our people, not just communicating, which the governor has done so effectively well, but also obviously listening. So talking to all the stakeholders continuously, working together to arrive at solutions, making sure that we do our best to help people understand the decisions that are being made and carrying everyone along. And going forward, this will continue to be the strategy. So our efforts will be focused on, now that where everyone's no longer sort of trapped in their houses and their effort is to keep them at home and to sustain them while they're home, the next frontier now is getting people to learn how to take responsibility. So social distancing, wear your mask, we have a wear your mask initiative, work from home as much as possible, self-report and isolate as may be required if you have symptoms or if you feel you've been exposed, observing strict hygiene, all the measures that we would require to be able to live over the long term and flatten the curve, continuously flatten the curve as we are in this new or now normal, as Babashola has coined. So of course, we saw some challenges on the first day, particularly around public transport and around banks, and we're constantly monitoring and managing and conversing with entities on all of those things. And I think I've been out, I was out yesterday, I was out briefly again today as well, and I can see, greater adoption of masks, better improvements in what's happening on the public transport side, and it seems our people are beginning to learn to live with it. So with continuous advocacy and particularly working with employers is extremely key for the private sector and other employers to really support in this process, equip your employees, continue to pass on the message, because government can't do everything and people may not want to listen to us, but they'll listen to you. So as individuals, as employers, it's also important that we all work together to pass on this information. The other thing that we'll do is, of course, we have to continue to keep our economy running. I love what Mrs. Adibowale said about COVID resilience assets. There are COVID resilient assets and even COVID, COVID positive opportunities. So there are new sectors, things we need to consider. Some of the things, for example, that became very apparent to us in this process was the need for data. So to be able to recognize more people, to be able to plan better. And those are areas people can go into. Healthcare, of course, which was always a priority for Lagos. We had increased healthcare spend from 8% of the budget to about 12 or 14% of the budget, and increased, of course, in absolute numbers, almost by 50% the amount vested towards or voted towards healthcare. And that we're looking to even move now to 20% by the recent announcement of the governor. So healthcare will remain a priority. Food security, as I said before, most of our food is imported, so we need to be able to sustain ourselves. So agriculture is going to be a massive, massive area of focus for us. The other thing we want to do is to support, not just to create these new opportunities and work with individuals and companies that are looking to get into them, but to also support the companies that are here and ensure that they stay afloat and keep jobs. So those are things we would be looking to do. We will continue to look to put in place facilities to cope with numbers if they continue to rise. And then I think those are the real things that we will be doing. So working with people to establish the habits that we need to have going forward, working with the private sector and investors to ensure that the opportunities are captured and business is sustained, and working to identify our people and continue to provide the interventions that are needed. In my office, the Office of Sustainable Development Goals and Investments, will be holding an investor roundtable later in the month to have the necessary conversations with investors and help work with them to thrive in this period. And above all, we'll continue to communicate and listen. Thank you.
Thank you so much, Roshalakwe, and letting us know that the state government does have a bouquet of initiatives at addressing the issues that confront the Lagosian and the Nigerian. I think we've overshot time by about 30 minutes or 40 minutes, thereabouts. We are now supposed to go into Q&A with the kind permission of the panelists, if you don't mind. Can we proceed into Q&A? And if you also look at your devices, you'll see that a few questions have been asked. Babajimi, I think Mrs. Fumi Roberts asked you a question, if you could address that. A couple of other questions have also been put to our panelists. So if you could just respond to that in Q&A. And then we can either take questions or answer, we could either answer them, verbally, or just write our responses. I'll leave that to the panelists to decide. If you look at just 2 questions in the Q&A right now, we could take them or respond via email or in a document.
I've observed that most of the questions initially were in reaction to Baba Jimmy's presentation. Most of them centered on force majeure. He's responding to most of those questions, but there's one by Fola Alade that's still open. So maybe Baba Jimmy wants to take that orally.
So, Zofu, do you want me to take that live or should I just type the answer?
I think maybe live.
Okay, his question is, in view of the technicalities involved in proving force majeure and frustration, how important will ADR be with specific reference to mediation, playing scheme of things? This can be taken. Okay, so I guess there's no gain in saying that any form of alternative dispute resolution will be very helpful in this COVID and the post-COVID era. There are bound to be a lot of disputes arising from the unique problems that this pandemic has caused. And I think that ADR, especially mediation, will come in very handy, especially when it comes to employer-employee disputes. And I would encourage the use of ADR for sure.
Thank you, Baba Jimmy. Okay, no, Baba, please go ahead.
Yeah, so I just wanted to mention, apart from our participants on this webinar via the Zoom application, apparently Dr. Adefula has also made me to understand that we had over 200 people that were viewing this via live stream on YouTube. So that would mean that we had well in excess of 400 participants and viewers of this webinar. I noticed a couple of people. Our immediate past chairman of the SBL, Olu Akpata, is still on. So is another legend, Femi Olubanwo, and they're just quietly listening as participants. If they have any questions for our panelists, please feel free to ask amongst a host of other familiar names. From this point, Ozofu, we don't happen to have any other questions written in the Q&A tab. So because of the time, where I think it's 3:15 now.
We actually had a few questions.
I sent you something, Baba Shola.
There are many questions for Sheyi, but I think she can. There are actually at least 3 directed to Sheyi, but I think she can respond by email.
And she types very quickly. I'm assured of that. She types really quickly. I've seen that. I saw that when we had our dry run. And the questions are now coming. I sent you something, Baba Shola. Yes, sir. There are many questions for Sheyi, but I think there are at least directed to and she types very quickly. I'm assured of that. She types really quickly. I've seen that. I saw that when we had our dry run. It appears technology is getting the better of us now, because I can see the sound being echoed of statements I made a few seconds ago. So maybe we shouldn't overstress tech and have those questions answered in an email or document to all our participants, acknowledging that we've tried as much as possible to be disciplined as professionals, to keep to time. It was pretty hard, but we did try. We're supposed to have ended at 3 o'clock. I think it's now 3:15, 15 minutes. I will then at this point hand over to my other partner, Bukola Bankole, for closing remarks.
Thank you, Baba Shola. Thank you, Zofu. And a very big thank you to our panelists. This has been
a very informative and educating session. I think what we can all take from this as well is we all know we're still learning, and these are unique times indeed, and we all have a part to play. So thank you to our participants. Your questions will be responded to, as everyone else has mentioned already. And if there's anything else, please feel free to shoot us an email. On behalf of the SBL, Section on Business Law, and TNP, would like to say a big thank you. The SBL and the Mergers and Acquisitions Restructuring Committee will continue to, host informative sessions like this, and we certainly look forward to you joining us on future sessions. So if you have areas you'd like us to focus on, please feel free to reach out to the relevant committees. The recording for this session as well will be made available to participants, and we will be broadcast on SBL's channels and of course on TNP's as well. So thank you. Enjoy the rest of your afternoon. Wash your hands and stay safe. Thank you.
Thank you.
That said, I want to particularly thank those legends: Sheikh Bickersteth, Benga Yubode, Aswe Godalo. I'm sorry, sir. Words of wisdom, the beard. I knew when the goatee was all dark and black, and it's all gray now. And we thank you immensely from Chairman SBL and the entire team. Thank you to all our panelists, Mr. Ukera, Sholakwe, Mrs. Longe, Mrs. Adeboale, Shei Bella, been fantastic. Mr. Everybody, if I could borrow that sculpture from you one day, I may not return it though, but I'd love to. Mr. Godalo, Mr. Candy Johnson, thank you, everyone. Thank you to everybody. Thank you to everybody. I'm really, really grateful. And this just shows the direction that we're going to keep going with SBL. Thank you so much, sir. Thank you so much, madam.
Thank you. Bye-bye.
Thank you.
Thank you.